A letter marked Jury Summons, issued by HM Courts and Tribunals Service, printed court crest, a reporting date, a Crown Court building, a time to arrive. Inside the envelope was a reply form. It had to be returned within 7 days. The form confirmed availability for jury service, or it allowed a request to delay or be excused. The form was not returned. The court system recorded no response. The name remained on the jury list, but summons stayed unconfirmed. A second letter was sent. Same heading, same case reference. This one was shorter. It stated the summons had not been acknowledged. Another reply form was enclosed. The letter warned that ignoring a jury summons can lead to a court fine. A second 7-day window was given. No form came back. No exemption was requested. No delay was requested. No explanation was sent. The court moved to the next stage. A new document was issued, a notice to attend jury service. It listed the exact reporting date, the same Crown Court, same arrival time. The wording changed. It now stated that failure to attend may result in a financial penalty issued by the court. The letter was delivered. The date approached. Nothing was sent back. No phone call, no online reply, no contact with the jury officer. The reporting date arrived. The court checked the attendance list. The name was called. No one answered. The court marked the entry, failed to attend jury service. That triggered the next step. The file was referred to a district judge. The judge reviewed the record. A jury summons issued, 2 letters sent, 2 reply forms enclosed, no response recorded, no attendance, no explanation. The judge authorized a financial penalty for non-attendance. The amount was set by the court, several £100s. A formal court fine collection order was produced. It explained that a fine had been imposed. It listed the amount owed. It also listed payment methods: online payment, telephone payment, bank transfer. The order gave a payment deadline. It also warned that enforcement could begin if payment was not made. The letter arrived. The payment window passed. No payment was made. No installment request was sent. No challenge was filed. The fine moved into enforcement. The court issued another document, a further steps notice. This notice explained how the court could recover the money. It listed several enforcement options: enforcement agents, deductions from benefits, or a deduction from earnings order. The notice gave a short time to respond. Payment could still be made. A payment plan could still be proposed. Nothing was sent. No response arrived. The court authorized enforcement. The chosen method was deduction from earnings. A legal order was prepared. The order was sent to the employer. It instructed payroll to deduct money directly from wages. The employer had no option to refuse. The instruction came from the court fine system. Payroll processed the order. The next payslip showed a new line: not tax, not national insurance, not pension, a court fine deduction, money removed before wages reached the bank account. Each pay period the deduction continued. The employer transferred the money directly to the court, not to a collection agency, not to the employer, straight to the court fine account. Only then did contact begin. A call was made to the court. The explanation was simple. Work had been busy. The letters had been put aside. They were thought to be reminders. The person asked if the fine could be canceled. The court checked the record. The summons had been issued correctly. The letters had been sent. Deadlines had passed. Attendance had been required. The court had already recorded failure to attend. The fine had already been imposed, and enforcement had already started. The deduction order was active. Once payroll receives that order, deductions continue until the fine is cleared. Stopping it is difficult. The court can review cases, but the summons had been valid. The warnings had been issued. The reporting date had passed. The enforcement order remained. Each payslip continued showing the deduction until the balance was fully paid. Nothing started in the courtroom. Nothing started with the judge. It started with a letter, a jury summons form, 7 days to reply. A form left unsigned, and the court moved forward without it.